Just yesterday evening when I was watching the news, the CS in charge of internal security, one Professor Kindiki, made some remarks pertaining to this case, and specifically about one Mackenzie, where the CS said, come rain or shine, Mackenzie will rot in prison. So we as a defense team wanted to know if this exercise we're taking, is it futility? So I was discussing the same with my other friend, Mr. Bakar, and my other friend, Mr. Ogega. But I felt that we need some assurance from the Chief Justice of the Republic of Kenya, Honorable Martha Koome. We want assurance from the Chairman of the Justice and Constitutional Affairs of the National Assembly. We want assurance from the DCI, one Mr. Amin. I also want assurance from the Chairman of Law Society of Kenya that our clients will get justice, fair hearing. Because as I address Your Honor, some of the respondents have now resorted to hunger strike. Your Honor, the ones that were uttered by the CS. Our clients take offense to this kind of statements. In fact, some are still in shock. And the same utterances, I must say, are quite demeaning. Kithure Kindiki holds a PhD in law. And whatever he stated was sub judice. The matter is in court. So we want to know if the said CS is running an independent judiciary or court apart from the one established by the Constitution of Kenya. Because the impression we get that the CS is a law unto himself. Further, our clients are yet to be charged. And we expect the CS and any other legal-minded person to assume them to be innocent until proved guilty. Now that the CS has judged them, so by way of repeat, may we know from you or from the Chief Justice whether we'll get fair hearing or not, or whether the statements that were made by the CS is a government policy. Because I believe anything uttered by a government minister means that is government policy. Is that the government policy that our clients will not get fair hearing? Now, finally, before I resume my seat, we have advised our clients, unless and until we get clarification from you, an assurance that they'll get a fair hearing as enshrined in our Constitution, Article 50, the rest, we are going to boycott any further hearing until we get an assurance that they'll get fair trial. The CS, Your Honor, if I may go further, stated in his address that he has always advised the courts to convict criminals, but the courts always take opposite views because of the law and the Constitution. Now, if he feels that our courts are incompetent, then may we invite other international bodies like UN to come and try Mackenzie? Your Honor, I undertake to share the said video with the court so that when you reach it, to make a determination or consider my application, you will come out with a balanced decision or explanation. But we feel offended, Your Honor. And as I address you again, Your Honor, I'm instructed to inform you that the police are now busy demolishing our respondents' houses, taking away their livestock. Last week when I was addressing you before my learned friend Mr. Jami cut me short, I informed the court that some of the respondents are being subjected to mental and physical torture. But I had to sit down before Mr. Jami raised some objection to that averment.
Noted the concerns that have been raised by counsel for the respondents. It is obvious that the remarks that were allegedly made by the Hon CS, Professor Kithure Kindiki, were not made for and on behalf of this court. This court cannot speak for the CS or any other person for that matter. As rightly submitted by the parties, the CS belongs to the executive arm of government, which is separate from the judiciary. The parties have rightly pointed out that the judiciary is an independent arm of government, and judicial officers and judges make decisions independently and without direction from any other person or organ. Judges and magistrates are only bound by the law and evidence. I do not wish to delve into the remarks that were allegedly made by the CS because now is not the right time nor forum. I will thus not speak for him. Having indicated that the statements were not made by this court, I perfectly understand the implication of such remarks, if at all, on the respondents. I'm aware that counsel for the respondents may be aware of the position at law that the court is not expected to be influenced by extraneous matters or statements not forming part of the evidence before it. However, the respondents are ordinary people who may not be versed with the law. Judicial function has a lot to do with perception and not just what the court actually does. Given the circumstances, I will understand if the respondents are apprehensive that they may not get justice owing to the alleged remarks made by the CS. The CS is a high-ranking government official, and to the ordinary citizen, his statements carry a lot of weight. I will not focus on what Mr. Makasembo feels as an advocate, but will put myself in the shoes of an ordinary citizen seeking justice in a court of law. Whereas I will not comment on the propriety or otherwise of what the Hon CS may have said, since the issue is not properly before this court, I see nothing wrong with the respondent airing their grievances and sharing their concern on the same. I'm not in a position to direct the own CJ or any other personalities to give any assurances to the respondents. However, as the judicial officer seized of the matter, I hereby assure the respondents that this court will administer justice according to the Constitution and other laws, and being guided by the material placed before it. They have nothing to fear.
The judiciary is an independent office, and so is the ODPP. And council knows better than to bring the grievances before the wrong forum. If council feels like he's aggravated by the statements made by the CS, and if there is violation of his client's rights, I believe the Constitutional Court is, apologies, I believe that if he truly believes that those sentiments violated his client's right, and if he truly believes that he wants to pursue the matter, instead of making declarations before this court, I believe the Constitutional Court is the most appropriate court. He can serve the offices is mentioned, and the offices will respond appropriately. Such declarations cannot be entertained without any form of application or any presence of the other offices to come and respond to what he stated. So, I believe that he's not addressing the correct forum, and he should be directed to the Constitutional Court. I also submit that the supremacy of the Constitution, and I believe in the integrity of this court, and that the accused persons at the end of the day will receive a fair hearing. As for sharing of a video that he has not presented before the court, I believe that the Evidence Act gives the appropriate way of submitting digital evidence. And if counsel does not follow the same way, I submit that the same be rejected. And unless he supplies us the video in the correct manner under the certificate, then the same is just hearsay from him. And lastly, counsel has submitted about his clients undergoing hardship under police custody. I still share the same sentiments of my senior, Mr. Jami, that the same should be put under affidavit so that we can actually cross-examine the accused persons who feel like their houses have been distracted. And instead of mentioning just police officers, he should give us a name so that we can follow up. I believe these are just declarations, just to create some form of hysteria that the clients are going through a hard time. I kindly request this court to not entertain such statements unless they are brought in the correct manner, that is in form of affidavit, so that the prosecution can be given a chance to cross-examine the people who are alleging any form of torture or that their houses are being distracted, and so that we can get to the bottom of this. I'm kindly requesting that the court does not entertain such remarks from the bench. That is all, Your Honor. The last thing I'd like to say is counsel should bring his grievances, if any, in the right manner and in the correct forum. Otherwise, this is just hearsay evidence and should be dismissed.
We've had a discussion with Mr. Mackenzie, and I had advised him in the same manner that I'm going to inform the court. Your Honor, this is a court of law. It is governed by procedure provided for in law. Your Honor, if you entertain anything said in the market or political forum, you will not be doing your work here. So, Your Honor, first and foremost, it is wrong, in my view, for Mr. Mackenzie to present what was said by the CS Kindiki in the manner he is presented before court. Many things are said outside there. Your Honor, the CS Kindiki is not a party to this proceeding. Your Honor, you've been asked and unfairly so, to make assurances. You know, my understanding, it's like Mr. Makasembo is addressing you like you're the one who made those statements. You are not the one to give assurances. You said nothing outside this court. You know, the CS belongs to another arm of government, the executive. The executive has no role. These are two independent arms. This is the judiciary, an independent judiciary. He has no influence or authority over this court. He cannot instruct you to do anything. And he's aware of that. You are independent. You took an oath. You've done nothing to suggest that you will not deliver justice to the parties before you. So it is wrong for Mr. Makasembo to ask you to assure him whether the suspects will get justice before this court. In fact, I humbly and respectfully implore upon him to withdraw that request. He should go find Kindiki wherever he is and ask him to withdraw those statements, not you. My learned colleague has said with confidence that they have advised their clients, if no assurance is given, they are going to boycott these proceedings. You know, it is unfortunate, it is wrong for an officer of this court to do so. You know, that is tantamount to threatening this court for a wrong that emanates from everywhere, from somewhere else and not from this court. You know, in fact, that is a breach of the overriding principles of the law. As advocates, wherever you are, whether you are a prosecutor, you are for the suspect, you are for the victim, we are bound to assist this court to deliver justice. And you cannot help this court deliver justice by advising your clients to boycott these proceedings for things that are said by somebody else who is not even a party to these proceedings. It is in fact dangerous for the defense to follow that route. So again, I implore upon Mr. Makasembo and his defense team not to do so, because that is a breach of their oath as advocates. Lastly, Your Honor, I concur with Ms. Ogega that the allegations that there are demolitions going on in Shakahola are not for this forum. The law provides for ways on how to present those allegations and address them. So now it is my humble submission that you advise Mr. Makasembo to present his sentiments elsewhere, not before this court. He has the assurance of the Constitution that this court is independent. Not even the Chief Justice can dictate to this court. So he should be assured by the Constitution, not by you for things done by somebody else. That's all.
You want to make a quick...
One, on the statement I made yesterday, which I want to repeat here. We will get Mackenzie and his collaborators convicted on the basis of evidence and the law. It's as simple as that. And the reason why I said that he will stay in prison forever is because I am aware the kind of punishment that is given to people who commit the kind of crimes he has committed. based on my professional background. I'm aware what kind of punishment is visited on such people. So he will not see the light of day. He will stay there for the remainder of his life, and then he can go and account for his crimes later on in the life hereafter. So I can say that without any fear of contradiction. The second issue.
Apart from that, there is an observation I wanted to make. May I recognize the presence of Mr. Baka, another friend, the advocate for the state and victims. I'm more than happy now that you need to know that you cannot blackmail you. Like an independent-minded person, a very serious magistrate. If you place politics in Chakahola or someone else, not in this court. It's just politics.
So we've agreed 14th, right?
Yeah, 14th.
Yes. You have filed. You may file, eh? Yeah.